Good evening, everyone, and welcome to our final Rights at Night session for the 22-23 school year. I am Lisa Morgan, a kindergarten teacher and current president of the Georgia Association of Educators. And we have with us this evening Mike McGonigal, our Director of Legal Services. And I think I'm just as excited as everyone else for this presentation because it's something new. It's a new one we haven't done before. And I asked Mike, I said, what are the top 10 questions you get? What are those questions that our members are calling in and asking about? And can you give us those answers? So that's what we're going to get tonight. And if you, as always, if you have any questions during the session, please put them in the chat. We'll make sure we get them all answered for you. Thank you once again for being here. And I will turn it over to Mike at this time.
Thank you, President Morgan. So we'll start. Do you see I should go start from the beginning, correct?
Yes,
all right.
You should.
There we go. Okay.
There we go. Perfect.
Here we go. As President Morgan said, we're entitling this tonight Top 10 Questions. But I went a little bit more than 10 because as I think of one question, there are, spin-offs from the main questions, and you might have some of your own. And if you do have questions, I think President Morgan said put them in the chat. If they relate to your own personal situation, I'd request that you either talk to me offline or speak with your UniServe director about personal situations that you have going on. If you have general questions to help clarify the law, that I'm happy to do in this particular forum. So I need to pitch legal services and what makes us better than any other professional organization in Georgia. Liability protection provides greater protection than the $1 million that other organizations have. But liability protection is for in the event that a lawsuit is filed against a GAE member. For example, a parent is alleging that their special needs student is not receiving free appropriate education under federal law, and so they file a lawsuit for the loss of those services and the loss of that education. That is a liability protection that provides up to $3 million if there's more than one suit filed in a program year. But we only, it's very important to have, but we only have maybe 5 to 6 or so lawsuits filed against members per year. It's very important to have. I'm not trying to undersell it, but I am trying to say that that's not the meat and potatoes of our program. The meat and potatoes are the employment defense and certification defense. And there you see the first bullet is what makes us far and away a much better program, and you get much more value for your money. We don't have any predetermined caps on the amount of legal fees or costs that we expend in defense of a member right, or when we go on the offensive, and you see affirmative lawsuits there, is something that the other organizations do not do. They do not file lawsuits against school districts. Affirmative lawsuits, you can easily start the attorney fee meter running at $20,000, $25,000, $50,000, and even upwards to 6 figures in complicated, particularly a federal court race discrimination type cases are very, very expensive. But when we do decide to take it on, we're all in. And all the attorney's fees and costs don't cost our GA members a penny more. It's just included in your dues. So that's a far better value for your dues dollars. So get into our top 10 or more questions. So I start off with one that sounds really basic, but I learned years ago that even our veteran members did not know the answer to this question, which I take as like, does the sun rise in the east? Educators do not have the right to inspect and copy the personnel files maintained at the school and or the central office. True or false? That's false. You do, as a public employee, have a right to inspect your personnel file. There's two locations, one maintained at the school location where you work and at the central office. They don't always contain the same records and documents. Here's another question. Does the school district have to tell you what they have placed in your personnel file? The answer to that is no, they don't have to tell you what they are putting in your personnel file. So that, brings up a very important question, that you need to check your personnel file at least once a year. And I say that it's an empowering step. I've learned that when a member goes to the front office at their school and says to the office assistant there, hey, I'd like to look at my personnel file. And they say, great, can you come back, after school, or come back tomorrow, and we'll have it ready for you. By the time the educator gets back to their classroom, half the school already knows that, Mr. McGonigal, oh my gosh, he wants to see his personnel file. And it's like, ooh, why does he want to look at his personnel file? Well, because it's my right, and I have a right to know what the district has put in my file, because they don't have to tell me what they're putting in the file. And you notice when I went to the front office and talked to the office assistant, they said, can you come back tomorrow? That's fine, that is legal. They can tell me to come back tomorrow or come back, I don't know, on Friday. That's legal, but you have an absolute right to have access to the file. But it's okay if they say, I'm too busy right now, can you come back in a day or two? That's completely legal. Can they charge you for making copies of whatever items you want in your personnel file? The answer to that is yes. The Georgia Open Records Act says the district can charge 10 cents a copy for copies that you make of records in your personnel file. Now, something to keep in mind is that if they don't charge, employees or parents or other folks, they just say, go ahead and make the copies and we aren't going to charge you. They cannot then come back to you and say, we're going to charge you that, 10 cents. And it may not sound like a lot of money, and maybe it's not, but they have to maintain consistency. If they're not going to charge, one group over here, they cannot then come back and charge you as the employee. And these days, what you can do, and it's that the quality is not so great, but if you take your camera phone, your cell phone, you can take pictures of the documents in your personnel file with your phone. Sometimes the quality is not so great, but it's free. So you can get away with that without any charge. I've known members to look at the file and maintain a log, like on a piece of paper, on a legal pad, and they will document the order in which they find each document in their file. And the reason they do that is because when they come back in 6 months, they're really looking to see if those papers are still in the same order, or has somebody else gone into the file, which, you know, the administrators might have a good reason to go into the file. But now you can ask a question. I noticed that the order of the records in my file are not in the same as I found them 6 months ago. Can you explain, you know, why, who was in my file and for what reason? You're perfectly well within your rights to ask those questions. When you're inspecting your file, they often do, and it's within their right, to have somebody in the room with you while you go through your personnel file. And that's common, and they're within their rights. They just want to make sure that you're not going to, you know, walk away with some document that's in the file. And for heaven's sake, don't do that. That would be theft. The personnel file is a matter of property law. It doesn't belong to you as the employee. You have access to it, but the records, the documents, the written material that's in the file is actually property of the school district. So that is not your personal property that you can just, you know, walk away with. And one last tip, when you're, with that in mind, since it's not your property, when you're looking at your personnel file and the records contained in there, don't write on those documents. Under no circumstances, if you make a copy of something in your file, you can write on the copy, but do not write on the original in the file, because that's, again, it's not your personal property. So everybody, part of your homework is in the next week or so, go and ask to see your personnel file, because it's your right. And you know, what are our rights if we don't use them, if we don't exercise them? Then they're just printed words on a book and they don't do us any good. So spend a few minutes, ask for that access to your personnel file, both at the school and at the central office. And you'll feel good about it. Based on my experience talking with our members over the years, you've exercised a baby step in a right that hopefully continues to evolve, and you take more baby steps and you begin to walk, you know, and then you start walking a little faster and a little faster. And then you may one day have the confidence to speak before the Board of Education on an issue. And it all began because you exercised your right to look at your personnel file. True or false? Question 2, after clocking out for lunch, a paraprofessional may be required to eat their lunch in the cafeteria without compensation. Well, this opens up a door to our ESP members, our educational support professionals. They are non-contractual employees. And then another slide will take a look at what that means. It's subject to at-will employment, meaning a paraprofessional or a bus driver, a maintenance worker, office assistant may be fired for a good reason, a bad reason, or no reason at all. That's a harsh reality that our classified employee members, ESP members, face in their work sites in public schools. But there is a federal law, and I have the link there to the Wage and Hour Division of the U.S. Department of Labor, to the Fair Labor Standards Act. So classified employees are covered and governed by their wages are governed by the Fair Labor Standards Act. Fair Labor Standards Act covers really only two areas of law: minimum wage and overtime. And within that, those broad categories, it also maintains and requires that if you are directed to perform labor or services on behalf of the employer, you're entitled to pay. So in this situation, this is a real case where a paraprofessional clocked out for her lunch at an elementary school in South Georgia. And the principal said, all right, well, go ahead and go eat your lunch in the cafeteria. And so she goes in and with all the other paraprofessionals as well, and eats her lunch in the cafeteria. And after, she has the lunch, she goes back to the front office and clocks back in. Well, that's illegal. That's illegal. Because what is the paraprofessional doing in the lunchroom? She is supervising the students. So she is actually performing services and labor on behalf of the school district at the direction of her supervisor, the principal. And just by the fact that you clock out does not wave fairy dust over the situation and make it a voluntary aspect. The part of the FLSA, Fair Labor Standards Act, says you cannot volunteer for something that you are supposed to be doing. And in this situation, clocking out and being told to go work in the lunchroom is compensable time. And so that was brought to the attention of the UNISERV director in South Georgia. She brought it to my attention. We worked it out. We gave the UNISERV director the cites to Fair Labor Standards Act. She said, okay, Mike, I got it. She goes back to the school district and we stopped them cold in their tracks. That practice of clocking out and being told to eat in the lunchroom was stopped. The paraprofessional got her wages paid for the number of times that she clocked out and ate in the lunchroom. And the district sent a complaint to the Professional Standards Commission against the principal for I think it would be a violation of Standard 1. Standard 1 meaning under the Code of Ethics, all educators are required to follow all federal, state, and local laws, rules, policies, and regulations, where here the principal was really just trying to get out from paying the paraprofessional who's not making a whole lot of money to begin with. But, so, and I can't tell you what happened to that Code of Ethics complaint, but I do know that that was one of the outcomes in that case. So that was very successful and a good example of the way that UNISERV directors work with legal services. Another aspect of Fair Labor Standards Act, sometimes a misconception, is that it entitles you to say like double time for what is called holiday pay. So if I'm required to work on a holiday, does the Fair Labor Standards Act entitle me to double pay? And the answer is no. Fair Labor Standards Act is only minimum wage and overtime. A common misconception, not all that recently, is bus drivers, school bus drivers would call and say, am I supposed to be paid for my pre-trip and post-trip inspection? The district, my manager, is saying, well, I'm not driving the bus, so they don't have to pay me for inspecting the bus before I begin the route and after the route. Well, that's illegal. Again, if you're being directed to inspect the bus before the route and after the route, again, that's real simple. It's like the paraprofessional being required to eat lunch in the cafeteria. you're being directed to perform some labor or services on behalf of the school district. So pre-trip inspection and post-trip inspection are absolutely compensable. And those bus drivers, we straighten those situations out too. Doesn't take a whole lot of arm twisting to get things straightened out. Usually, if we show them the law in black and white, and Fair Labor Standards Act is black letter law. Once we show that to them, they're the game's over, and they will change up their practices and begin paying our bus driver members and classified employee members, our educational support professional members, the wages that they're entitled to. Oh, this is the slide, just briefly. Just wanted to, I guess, I don't know, dramatize how long this at-will employment doctrine has been in existence in Georgia. And you can see the first reported Georgia Supreme Court case goes way back before the Civil War. This is the first reported decision from the court enunciating the at-will employment doctrine. And it basically says, because the plantation overseer did not have a contract for a definite term, that meant he was subject to an at-will employment. So he couldn't sue based on a contract because there was no written agreement, there was no oral agreement. It was just an arrangement where the overseer performs services, say on Monday, and gets paid for Monday's pay. And that's all that he was entitled to. So there was no long-standing employment relationship at any time. As you see, that at-will employment doctrine is then reduced to Georgia Code. Title 34 embodies and codifies the at-will employment doctrine here in Georgia. And I put the definition from the statute in there, right there. An indefinite hiring may be terminated at will by either party, And Georgia is one of only 2 states in the country that doesn't have any exceptions to it. So we're talking 170 years, and Georgia has not changed its position and perspective and legal doctrine relative to the at-will employment doctrine. What they say is, now that it's been reduced to this statute, Title 34, the Georgia General Assembly must enact an exception to the rule. Like some states have an exception called good faith and fair dealing. That you maybe have an at-will employment relationship, but the employer still must deal with the employee in good faith. And if you're able to show they weren't in other states, you'll have a successful lawsuit. But so far, Georgia's General Assembly in 170 years has not taken those steps. So I guess we have room to improve there, a long way to go. And there's a good, it's a short law review article. I include that in there for those who want to get into a little bit more deeply into the doctrine. And Professor Ballum will take you down the pathways to history and teach you what was happening in Georgia back in the middle 1800s and how this doctrine evolved. True or false? A school employee caring for her migraines can be terminated for her 12-week absence from work. True or false? Okay, that's one of the questions we have. Well, that is false. The Family and Medical Leave Act entitles all employees, that's classified and certified, active members, ESP members, for up to 12 weeks absence from work to care for a serious health condition, to care for a immediate family member who has a serious health condition, or for the birth or adoption of a newborn child. One of the prerequisites is it also requires that the employee have worked for the school district for a year before you're entitled to the FMLA leave, and it must have been for full-time work. So as long as you get past that first year of employment, you will then be entitled to the up to 12-week absence from work. Migraines happens to be mentioned in the statute as a serious health condition. This particular slide is also a real example of a classified employee, a school bus driver, who had migraines. And when she felt one coming on, say in the morning before she, left home to go to the bus barn and, get her bus ready to go on her route, she would take pain medication for her migraine. Well, that had the effect where she really couldn't drive. So on those occasions, she would call into the bus barn and tell the school district that she won't be coming in, she's having a migraine, and she will, keep them updated, as appropriate. Well, this went on for, I don't know, can't remember all the details. Let's just say 6 months or so. And at the end of the day, the school districts, this particular school district fired the bus driver for not checking in with the school district when she had a migraine. And what occurred here and what saved the day was the bus driver kept a daily log. Again, I think she had a spiral notebook, but she wrote down the day and the time of when she called into the bus barn and who she talked to. Now, one of the things the district was saying was that she didn't always speak to the bus barn manager, and that may be true. But if these are informal situations, and if somebody is going by the reception desk in the bus barn, they're going to answer the phone, and they are. It doesn't matter who it is. They are then on notice that our member would not be in to do her route because of her migraine situation, and then they become liable. Well, long story short, I contacted the district and submitted all of the contact information that our member had maintained in a spiral notebook. The date she called, the time she called, who she spoke to, and they were not so impressed for whatever reason. So I sent the virtually identical package to the United States Department of Labor Fair Wage and Hour Division, and it had one of the quickest turnaround and settlements that I've had in my career. Within 10 days, the U.S. Department of Labor had called and said, what do you want? This is clear violation of the Family and Medical Leave Act. And so we got the member her job back, back pay, out-of-pocket medical expenses that she incurred while she was terminated. She got her old bus route back in a brand new bus on top of it. So they were wrong, and they knew it, and they got caught. So they wanted to And I give them credit for, doing the right thing and making the member whole. Trying to think what else I can say about the Family and Medical Leave Act. Well, the district can require you to fill out a medical certification form. There are some forms to fill out. The district, I don't like this part of the law, but it is the law. They can choose whether it's going to be paid or not paid. Even if you have built up accumulated paid sick leave, the law gives the employer the right to determine whether or not the FMLA leave will be paid or not paid. That's just how the law is written. And as you know, laws are creatures of compromise, and this is just one of those compromises that folks in Washington, made back in the day. I think when George Bush Sr. was president is when the law was originally written, and that provision hasn't changed since that time. Another federal law. The local board of education must provide reasonable accommodations to the known disability of an employee. ADA.gov. Or you can also go to EEOC.gov and you'll find your way into the Americans with Disabilities Act guidance section. And so that basically is a synopsis of the ADA, that the school board must provide reasonable accommodations to known disabilities of an employee. It gets into all kinds of questions. You have to put your request in writing, and it really best case is that you have your doctor, a certified medical provider, physician, put in writing what it is that you seek that will level the playing field to make you successful in your job. And so a real simple one would be, if I have diabetes, my accommodation request is to have some food in my classroom. Well, the district has a policy that you can't have food in your classroom, so I'm denied bringing in snacks or a candy bar into the classroom due to the no food policy, no exceptions. Well, that argument will fail under the Americans with Disabilities Act. It is designed to level the playing field. And even though the school district has a legitimate policy of no food in the classroom, they don't want bugs, they don't want mice, we get all of that. But the ADA entitles the employee with diabetes, documented, that their health depends on these snacks despite your no food policy. So that's a fairly simple one. Another simple one, it doesn't mean they're granted automatically, is say you have arthritis in your knees or your hips or something, and you are unable to stand for long periods in the classroom. And so now one of your duties as a teacher or paraprofessional is to circulate around the classroom. So you're on your feet for extended periods of time. Well, if your doctor can substantiate your health condition, the disability, arthritis, and as an accommodation would be to sit for whatever period of time it is, for a few minutes, or I've seen, can I have some carpet squares placed in the classroom because the floors are hard, but if I have carpet squares and I can stand on them, that makes my job a little bit easier and makes it a little bit less stressful on my arthritic knees. Or can I wear, tennis shoes, instead of flats or something, I need tennis shoes that will make the experience of arthritis more tolerable. and less stressful on my health. So those are fairly straightforward. A disability must mean that you can do the job. If you have a disability where you can't do the job, then you're not really, for purposes of accommodations under the ADA, you're just disabled, and you need to investigate short-term, long-term disability. But the type of disabilities that can be accommodated, like we discussed, diabetes, even the migraines in the FMLA case, the arthritis, things of that nature that are chronic, long-term, they just won't go away. That will get you into the definition of disabled individual, and you can do your job. All you need is a reasonable accommodation. I think the last thing I might mention on accommodation is it has to be reasonable. It's not my wish list. You can expect some back and forth with the school district, but just understand that it's not my wish list. And sometimes there's tensions and there's back and forth about what is reasonable and what is not. And if at the end of the day, we're dissatisfied with their responses, there's always resort to the grievance process or letters to the district or filing a charge of discrimination with the Equal Employment Opportunity Commission for a failure to provide a reasonable accommodation, for example. So we can get into some First Amendment issues here. An educator's public out-of-class statements on controversial political or social issues which do not involve criticism of his or her employer or co-workers are constitutionally protected. True or false? That is true. That is true. But you notice if you break it down, several components to that. You can speak on controversial political or social issues as long as you're not invoking criticism of the school district. Your comments can also be about school district policy, say, for example. Like if I want to speak about the low pay for maintenance workers or bus driver members, everybody, that is protected speech because it is on a matter of public concern. All tax-paying members of the county where you work would have an interest in hearing from you about improving the pay or the benefits of our educator members, whether they're teachers, paraprofessionals, bus drivers, maintenance workers, custodians. That's something that's a matter of public concern. If I show up at the same school board meeting and I want to complain about how my principal is being unfair, is a bully, he or she is nitpicking me and shows up in my classroom 3 times this week unannounced and gave me the write-ups. That's a personnel matter, and that is, first of all, they would probably say that's not appropriate. Let's talk offline, off to the side, and they would be within their rights because it's not a matter of public concern. It's a personnel matter. It's more of a private matter between me and the way I'm being evaluated. And it isn't something that is going to be given a forum at a school board meeting. But I think we'll have a next slide, but a couple of tips though. And we encourage everybody to, work up the courage to speak at a school board meeting. And when you do, it's important to layer on different statuses that you have. You know, I'm the president of a certain association, or I'm the member of my local association, proud member of NEA, GAE, and Cobb County, DeKalb, Paulding, Valdosta, Chatham, Savannah, Muskogee, on and on and on. I also want to inform them, if I live in the county, I'm a tax-paying citizen. I'm a tax-paying citizen as well as a member of GAE, and I'm an employee, but I'm on top of me being an employee, I'm going to add other statuses. And I might be an aunt or an uncle, a parent, grandparent to students in the school. So you should use your social connections or your social statuses in order to layer on those protections, because you just don't want to stand out there as an employee. You should take advantage of your other social and taxpayer statuses to gain more leverage with them. And they will hear you, and you should not fear any retaliation under those circumstances. If they do, you know, you've already taken the first steps to protecting your job and your career by adding those statuses to your remarks. So here's a few. Let me try and move this around. So what's protected here? Number one, so you participate in a weekend rally protesting police brutality. That's protected. Take it a step further and say you participate in a weekend rally and get arrested. Can the school district do anything to you for your lawful, legitimate, all-American, apple pie right to protest government policy? No, they cannot. And we had such a case like this in Gwinnett County several years ago, where one of our members participated in a weekend rally protesting. It happened to be immigration policy, and he was arrested. It was on, Channel 2 and Fox and all, all the rest showed him getting led away in handcuffs and all the rest of it. Well, this was over the summer months. And wouldn't you know, when he gets back to school after the first, few weeks or month, the principal calls him in and said, "Hey, I heard you were arrested over the summer at a rally." And it was all over the news. That does not reflect well on our school. And it doesn't, you are not a role model for our school. That behavior is not appropriate or conducive to our school culture. And so this principal wrote him up on his TEKS evaluation for being unprofessional. And in addition to that, his other evaluations went down after the principal found out that he was arrested. He came to us. We told the district this is a real no-brainer. If you remove all those negative references to being arrested from his TEKS, that'll be the remedy we seek. And they just simply ignored that. So we filed a lawsuit in federal court against Gwinnett. And again, once that was filed, it was settled within a month. But guess what? I mean, it was so unnecessary. The district had to pay GAE attorney's fees, and they had to pay at that point the member compensation for everything that he was put through as well. So it ended up costing the taxpayers needlessly for some really, just, I hate to say, just really dumb thing to do, is to write up an educator for exercising their constitutional rights. So number two, you got to see if I can move this. You post on your Facebook wall a local newspaper article favorable to a political candidate. Yes, that's protected. You can absolutely do that. The question that comes up with members sometimes is, do you want to? Do you want to broadcast your personal political views, to the public? Well, you can, and you're protected from that, even if the school that you oppose, say, a school district candidate, and you favor somebody else who's running against the incumbent school district candidate. They cannot retaliate against you. Posting on your Facebook wall is no different than having a yard sign in your front yard or a bumper sticker on your car. It's First Amendment protected speech. You write a letter to a publication that is critical of, I'm sorry, I'm trying to move this screen around. That is critical of the school board for one of its actions or ideas. Yes, that's protected as long as it's a matter of public concern. Remember, you can advocate for higher wages, higher benefits, whatever district-wide policy you have that you want to talk about. You can criticize the policy, but you can't criticize, personalities or people. Like my principal is nitpicking me and writing me up needlessly, things like that. Excuse me. There we go. You attempt to speak to the Board of Education about local policy, and the superintendent's investigation into the policy is for an unspecified period of time. Well, that's actually a case we did up in Walker County, where one of our members wanted to get on the board's agenda to talk about the grading policy. And their board policy said that when an employee or a member of the public wanted to get on the agenda, the superintendent could investigate the topic on which they wish to speak. Well, the problem with their policy did not specify a time period that the superintendent had to come back with the investigation results. Long story short, because their policy gave the superintendent unfettered discretion and no specified time period within which to investigate the topic of discussion, the federal courts permanently enjoined that policy, and Walker County eventually had to change their public speaking policy to ensure that all citizens and all employees had fair and equal access to speak to the Board of Education. Well, number 5, I include, because we're in an era now of tremendous backlash after George Floyd and Black Lives Matter, that, there's lots of questions around these topics, racially tinged topics. So if you're instructed not to discuss students your personal opinions on political matters, that's one. And in a classroom discussion on racial issues in America, you tell your students you've recently participated in the Black Lives Matter demonstration. That may not be protected, and it's because you've been instructed specifically not to discuss your personal political views with the students. You're just supposed to stick to the curriculum. And that comment that you personally participated in a Black Lives Matter participation may be imparting your personal views on political matters to the students. Now, I haven't really seen this happen. In fact, I see as much districts allowing, like if I have a Black Lives Matter flag in my room or a poster, educators in many occasions aren't asked to take them down. There is a law now, though, HB 1084, Students First Protection Act, signed last year, which some of you have been following, because GAE and NEA, Southern Poverty Law Center, are planning on suing the state over a law which says, on the one hand, you can teach about slavery in the country's history, but you can't make anybody feel uncomfortable about it. Well, there you go. The law is very vague. When educators are educated on the law, it raises more questions than answers, and puts educators who teach history, social studies, in a very precarious situation, meaning that they really don't know how to teach slavery properly anymore. And so they begin to self-censor the way they're going to teach after this law had been passed. I'd even seen it come into play. This is kind of a spin-off with an art teacher called, shortly after the law was passed, and she's teaching art, and a parent complained on her for teaching, she used the phrase critical race theory in her art class. And she said, well, what's that all about? Well, she had a meeting with the principal and the parent, and apparently she was teaching, according to the state curriculum, current affairs through the medium of art. And she had a painting of George Floyd, Ahmaud Arbery, and Breonna Taylor, and they discussed the subject matter through, an artistic lens, composition, color, dynamics, how the art, and then of course you do, according to curriculum, you can discuss the social meaning and social import of the particular work that they were assigned to study. Nothing happened to the educator. A meeting with the parents sufficed, but this art teacher was then put in a quandary. She was saying, well, I usually teach, other artists who might have, may have been gay, and their art may have been about fighting HIV/AIDS or something like that, and the fact that the artist's status as a gay person, am I able to teach that anymore? Is that some parent going to call that critical race theory, or is that a divisive concept? So the laws that have been put on the book since last year are causing a lot of censorship in the classroom, and a lot of it isn't being talked about unless us lawyers pick up the phone and talk to those who are actually delivering instruction. So now we're going to get into some contract questions, since we're still dealing with, contracts.
Mike,
Yeah.
I want to give you a quick update. We're almost at 7:25.
Okay.
Yep.
All right. True or false? All certified employees are entitled to a written, I'm trying to move this, entitled to written employment agreements. Yes, that is true. That is true. Now, certified, this law was written before paraprofessionals had to have certification. So that does not mean paraprofessionals, but it means teachers and administrators. They're entitled to written employment agreements. True or false? A signed letter of intent is a valid and binding employment contract. False. No. And GAE, you can credit GAE for putting that sentence in the statute 20-2-211B, because we were tired of fighting silly battles over administration saying you signed a letter of intent, so therefore you have a contract returning for next year. And so we convinced a majority of the legislature to put that in the statute that governs contracts to end those silly and needless battles. True or false? Teachers are entitled to a minimum of 3 3 10 days. No, that's a typo. They're entitled, forget about the 3 for now. Teachers are entitled to a minimum of 10 days to review their employment contracts before signing and returning. Well, the reason 10 days is there is because that is the law in 20-2-942. Do you know what that's from? What we call that? They call that the Fair Dismissal. Now, why is that important? Because many school districts have waived your Fair Dismissal Act rights. So you need to check your local school district policy to see if, A, have they waived your Fair Dismissal Act rights? If they have, then they've waived your 10-day contract review period. You then need to check to see if there's a written policy that governs how long you get to review your contract. Is it 3 days? Is it 5? Is it 7? You know, what is it? So, but we're in a world of waivers right now. And if you're, again, school district waived the Fair Dismissal Act, you don't have the 10 days anymore. You know, in their infinite wisdom to waive fair dismissal, they also waived your, not only your due process rights, but your contract review period. Educator contracts are required to include the amount of compensation to be paid during the ensuing school year. Well, very interesting. GAE just won a big Court of Appeals case 2 weeks ago. One of our members was tendered a contract, and his contract said that the amount of compensation was going to be based on the salary schedule in place currently. But if you notice, the law says amount of compensation to be paid during the ensuing school year. That's next school year. So the Georgia Court of Appeals found that that offer was non-conforming. So in other words, it didn't conform to the statute. Question is that it's an invalid offer. What happened in that case, and we'll go to the next question, true or false, when written notice of non-renewal has not been given by May 15th, employment is continued for the following school year unless the educator chooses not to accept employment in writing by June 1. Well, in this Court of Appeals case, the court said, back up here, there was a non-conforming offer which the educator was supposed to have accepted by, I forget the date, let's say May 1. The district gave him like 2 weeks to accept. He went on the portal, he accepted it, they said we didn't get it, okay? He went back and accepted it on May 31st, and there is evidence in the record that he did. The school district said, well, we see that you accepted the contract, but we're not going to recognize it because you didn't accept the offer by the date we told you to accept it by, right? Court of Appeals said, you messed up because you gave him a non-conforming offer of contract, didn't follow the amount of compensation the court said should have been a dollar amount for the next school year, the ensuing school year. And they said you didn't give him notice of non-renewal by May 15th. That's your second mistake. And the educator did not resign by June 1. So he had a contract, a valid contract for the next school year. That's yay. And the icing on the cake is the court said that the district does not have a defense of sovereign immunity. Sovereign immunity is this long, complicated defense that governments can use to say you don't have a right to sue. But if you have a contract with the government, you don't have the sovereign immunity as a defense. So this blows open potentially school district standard approach to how they make offers of contract, and the deadlines they impose on people, as well as the sovereign immunity offense when the contract is renewed by operation of law. Those are all brand new precedent-setting issues that our case resolved, but it is on appeal. So more than likely, this case will be heard by the Georgia Supreme Court in the next year. So, you know, keep your fingers crossed on that. Tenure, the word tenure is not in the Fair Dismissal Act, but for those districts that have tenure, it means that you've accepted a 4th consecutive school year contract from the same local board of education. And once you have acquired tenure, that means you can't be demoted or your contract may not be renewed except for the reasons set out in the Fair Dismissal Act. How do I get out of my contract? Well, there's 2 main pathways. You can resign. A resignation is a unilateral act. You can resign at any time from your contract, but just know there are certain important dates that you can resign without penalty. You know, there's a next slide will show you what those dates are. Or you can be released from your contract. You can go to the district and ask, may I please get out of my contract? So resignation's unilateral. A release, I'm not guaranteed a release, but that's the other way I can get out of my contract. Let me jump to the slide though. This is a slide though about resignations that I want everybody, you can, you know, take a picture of this with your camera. These are the dates that you can get out of your contract. So if the district, they must offer you a contract by May 15th. If they don't, then by operation of law, you have a contract for next year. You can resign not later than May 1st. Now that is the statute 20-2-211B. Professional Standards Commission has internal guidelines that grants you an additional 2 weeks to resign by June 15th, and the PSC will not sanction the educator for a breach of contract. With contracts coming out earlier and earlier, some districts, they've been out, let's say I signed my contract last week for the 23-24 school year. The law says I have till June 1 to resign from that contract. So if I find a better paying job or something closer to home, I have a right to resign not later than June 1st. They offered me a contract. They didn't non-renew me. Statute says I can resign by June 1st. PSC says I can resign by June 15th. PSC has these breach of contract guidelines. This is just part of them. You can find the full document on the PSC's website. The one that comes into play, the one we see kind of more and more, is the payment of liquidated damages by the educators considered a release. Liquidated damages, if you don't have those in your contracts, be grateful. Some districts will have these provisions that say if Mike wants to get a release out of his contract, he has to pay the school district $3,000. I mean, or insane amounts of money in order to be released from the contract. We have sued DeKalb County a few years ago on behalf of 2 members who, these 2 members, they resigned before June 1st, mind you. Before June 1st, we maintained they had a right to do that without penalty, and yet the district deducted $750 from their final paychecks as liquidated damages. Liquidated damages is supposed to be the cost to the school district to replace you. In depositions, the HR director and the superintendent at the time, and I love Michael Thurman, but Michael Thurman said, we just kind of made up $750. It really isn't based on anything. It's really kind of arbitrary. So we won our summary judgment. The district had to put $110,000 into a court administered registry. And everybody who filled out a form and could prove the district took the $750 out of their paycheck, the court wrote them a check for $750. And the district, as far as I know, and Madam President, you can tell me, they have not had liquidated damages in their contract since. Is that still the case?
It was through 1920. Since then, you know, I've been in this position, so I haven't been getting an annual contract to read.
Very good, very good. Well, I haven't gotten any calls from DeKalb members over
Right.
liquidated damages. And you also see the taxpayers of DeKalb County had to reimburse GA $50,000. But that's another example of where our legal program is superior to other programs. You know, a case 750 times 2 is, you know, $1,500, but we sued and we got 110 back, and we got back $50,000. And I don't have $50,000 to go sue over a $750 deduction from my paycheck. And this slide just shows it's just another occasion where we sued the Griffin Spalding Schools District on the same issue, but they said that our lawsuit was unprofessional and they were threatening to eliminate payroll deduction because we were advocating on behalf of our members. So what that did, that opened up another lawsuit, a First Amendment lawsuit, because the district was singling GAE out on payroll deduction because we are GAE. They weren't going to remove payroll deduction for any other organization, just for GAE. So again, we sued in federal court, violation of free speech and association. And again, settled quickly and favorably, and the district had to, once again, reimburse GAE for legal fees. So those are the top 10 or 15 or 20 questions. Thanks for your time. Go ahead.
Mike, we did have one question earlier about FMLA. That can schools require you to apply for FMLA if you are out for 3 or more consecutive days?
Yes, they can.
Okay.
As long as it's done across the board and consistently. The FMLA says that that's one of the definitions of a serious health condition. If you're out for 3 or more consecutive days, that's a qualifying event. Now, if I'm out with a bad case of the flu, that's not going to be a serious health condition. It's going to be me having a flu for 3 days. But
okay.
Yeah.
Okay, that was the question. And that was the only question we had. Before we leave this evening, we talked about it. Some of you heard when we started. I am going to put in the chat the link. Tomorrow is Sine Die. It is the last day of the session. The voucher bill, which started out as a universal voucher that any student in Georgia was eligible for $6,000, has been pared back, although the amounts increased. It's now $6,500 for students in the lowest 25% of schools based on CCRPI. It is on the table. It was tabled in the House Thursday. When it was brought to the floor, they had 2 hours of debate. It can be brought up from the table at any time and voted on. Thanks to our members who have been emailing and calling their legislators. So thus far, it has not been called up and voted on, which likely means they do not have the vote yet. So I put the link in the chat. The link is in your legislative update earlier today. And if we have your cell phone number, you got a text earlier today asking you to please email them. I know some of you have emailed already. I know some of you have emailed multiple times. Send another email, please. We have until midnight tomorrow night. So we have about a little over 28 hours to ensure that our public funds remain in our public schools. So please, please, please click on that link and send your email. And thank you all for joining us this evening. And we will upload the recording for everyone on our YouTube channel, GAE Voices. Thank you for being a member of GAE, and you all have a great evening.